associations and at professionally managed associations as far as the transfer packet. And where you have the same level of professionalism, particularly in electronic packets, that the compensation for the work that goes into providing that transfer packet will be the same for self-managed and for professional managed. Unfortunately, we're not ready quite yet with all of the details, and I will conclude with two observations. One, we hope that the Housing Commission will continue its interest. We will be definitely working with the respective associations early on so that their package can take it. And I look forward to at least being able to address two additional issues, and that is that when it is a professional package, even if done by a self-managed, then we no longer have the issue of when the fees for that packet come in, but they're at time of settlement, and as well as, again, encouraging through a fee structure people to do electronic production. Thank you for your patience, and with that I ask that the bill be tabled.
Thank you, Delegate Watts. And my understanding is the stakeholders, the primary stakeholders are the realtors and the common interest community that you'll be working with. And I see Elizabeth is in the room representing the Virginia Housing Commission and willing to take up this issue in the off session. So with that, based on the patron's request and confirmation from commission staff, is there a motion to lay on the table and refer to the commission, maybe by a letter, if we still do that?
I would appreciate such a letter.
Motion is probably made and seconded. All in favor indicate by saying aye. All opposed? Thank you, Delegate.
Thank you.
Delegate Ori. House Bill 1475.
Yes, sir, Mr. Chairman, members of the subcommittee.
It's a straightforward measure.
I'm going to be requesting an amendment nature of the substitute, but let me walk you through what I'm going to ask the language to do. If we could reinsert all the old language and strike all the new language. And then, on line 24, after used, comma, strike the and on line 25, after living, insert and the fact that this is a legal document. And that might not be the best wordsmithing, Maria will let me know if it's not, but the long and the short, Mr. Chairman, members of the subcommittee, the genesis of this legislation has been brought to me by a number of homeowner association groups where home buyers that go into the home buying process, they've gotten the packet of 52 pages of the homeowner association covenant, and they're so enamored with the purchase of this wonderful new home, they kind of pay cursory, if any, attention. And all I want to make clear, while we're giving them this information, I think they further need to understand, maybe they need to slow down the train, but I don't want to put the brakes on it, that, you know, it's kind of a buyer beware. But they need to understand when they sign that deal, they have signed a binding legal contract of whatever the HOA provisions are. There's one instance in my district that's brought this to bear in particular. There's the one community where the HOA covenants as a part of the proffer by the developer include the perpetual maintenance by the HOA association of the right-of-way of 2 miles of entrance road to the development, with specificity of what types of ornamental trees will be maintained, ornamental plantings, a fountain, and all it is listed in the HOA covenants is as common areas with nothing specific. So they needed to do a little due diligence to know what was there. Obviously, these folks did. And last year, the homeowner association ponied up roughly $250,000 for the maintenance of this right-of-way, primarily. So it's a contract. They need to understand it's a contract. It was one the developer wrote when he created the HOA and proffered to the county, knowing he would never have to pay a penny of it. But it was legal. It was all fine and proper. But I just want to make clear on the current one-pager, we have one more little bullet to the effect, you're signing a legal contract and agreeing to say. That's it. Marie, do you understand the concept of where I'm headed?
Thank you, Delegate Orrock. And for purposes of the subcommittee, I think if you understood that the delegate was requesting in 18 and 19, basically going back to existing law and then striking and in 24, and then adding comma and something to the effect of that this form is a legal and binding document of some nature. I think we can clean that up. Without objection, we'll adopt the patron's amendment to his own bill, House Bill 1475. Is there anyone in the audience who would like to speak in favor of this legislation as amended?
Chip Dix on behalf of the Virginia Association of Realtors, and we support the bill as amended and discuss the amendments with the patron.
Thank you very much. Anyone else in favor of this legislation as amended? Is there anyone here that would like to speak in opposition to the legislation? Are there questions or comments from members of the subcommittee of the delegate?
Obviously, it doesn't go to
And we have a motion to recommend reporting House Bill 1475 as amended and properly seconded. Any discussion on the motion? Hearing none, all those in favor indicate by saying aye.
Aye.
All opposed? Thank you.
Thank you, Mr. Chairman. That's supplement.
Thank you.
Send electronically.
Delegate Ware. Thank you. House Bill 1556. I appreciate your patience as we got through full committee, as well as those I know accompanied you to address your legislation.
Thank you, Mr. Chairman. And I do have a substitute, and I think Maria has that and can present it to you. This is one that has been worked out with a number of interested parties. I would ask you to adopt the substitute.
Okay, without objection, we'll adopt the substitute offered by the patron to House Bill 1556. Delegate Ware, please tell us what you're going to accomplish with this legislation.
All right. Mr. Chairman, I will give you a brief statement, but I do have a gentleman from the Appraisal Institute who can give a little bit further amplification. In general, Virginia state law requires a licensed appraiser to conform to the uniform standards of professional appraisal practice in all instances. A couple of years ago, this practice retired standards 4 and 5, which allowed real property appraisal consulting and reporting. The result is that appraisers in Virginia can only perform appraisals that conform to USPAP. This bill would allow appraisers to do work that doesn't conform in this fashion and for this reason. When federal law does not require compliance with USPAP, the reports as a result will be less expensive and perform more quickly when the criteria allows it. Kind of to put it in a metaphor, we don't have to sell you the whole dairy when you want a glass of milk. The appraiser is the one who's involved in a transaction who doesn't have a vested interest in the outcome, and the purpose of a licensed appraiser is to protect the public. The current requirement for Virginia appraisers to conform prevents them, at times, from protecting the public when USPAP is not required. That's a short version of that. And this is Mr. Scott DiBiase with the Appraisal Institute. I should also note and thank representatives from both the Association of Realtors and the Virginia Bankers Association who have worked with us on this, I think, to make it a better bill at the end of the day. And I believe they're both in support. They can obviously speak for themselves.
Delegate Ware, just very briefly, so in my mind, I understand what you're doing. Existing law allows an employee of a financial institution or lender to do this, and basically you're adding licensed residential real estate appraiser, certified residential real estate, certified general real estate, and all just concerning real property appraisers, not commercial appraisers. Is that correct?
That is my, yeah, that's correct.
Oh, including.
It does include commercial.
Okay, just want to make sure. Thank you very much.
Thank you very much, Mr. Chairman. My name is Scott DiBiase. I'm with the Appraisal Institute. We are in strong support of this bill. The patron has done a fine job of explaining its purpose to you. Very small but important change to allow appraisers here in the Commonwealth to provide a service that they're currently precluded from providing, and that other non-appraiser service providers are allowed to offer. So lots of new business opportunities for appraisers to provide evaluations when a full appraisal is not required by federal law. So thank you very much, and we thank the patron for bringing this bill forward.
Thank you very much. And Doug Bull would like to ask a question briefly.
Yeah, a quick question, and so additional jobs notwithstanding, it's kind of a two-way street in terms of protecting the consumer. And so can you just give me a little bit of an idea of, I guess, what's missing from the glass of milk report as opposed to the whole cow report?
Sure. There are some standards under federal law and federal policy called the Interagency Appraisal and Evaluation Guidelines that outline exactly what needs to be included in an evaluation. It is somewhat less detailed and involves less analysis on the part of the provider of that service, whether it be an appraiser or somebody else that's providing that service now. We actually think that allowing for this change would improve consumer protection because now appraisers would be permitted to provide services that unregulated parties are currently providing. So financial institutions have told us that they want to be able to use appraisers, but currently are precluded from doing so because an appraiser can only provide an appraisal and they can't provide an evaluation.
Thank you. And well, it's drawn to the code section dealing with exemptions from licensure. You can see that. Okay, thank you. Anyone else in favor of the legislation?
We've got a number of people who could speak.
Sure. Thank you.
Mr. Chairman, thank you for your support. My name is Alex Uminski. I am a certified general in the Commonwealth of Virginia, and I am in support of this legislation. Thank you.
Thank you very much. Anyone in the room doesn't support this legislation? Step forward. Okay, sounds like there's peace in the valley with the bankers as well as with the realtors and anyone else who might be a stakeholder. So, any further discussion or comments from members of the subcommittee?
Move report.
We have a motion to recommend reporting House Bill 1556, amendment in nature of substitute, probably second. Any discussion on the motion? All in favor indicate by saying aye.
Aye.
All opposed? Thank you, Delegate Ware.
Thank you, Chairman, members of the committee.
Thank you. We have Delegate Lopez, 1869.
Good evening, Mr. Chairman. Mr. Chairman, good afternoon, members of the committee. 1869 deals with pest mitigation. Under current Virginia law, there is a bit of confusion about who is responsible for pest elimination and the costs associated. In 55248.16, tenants have an obligation to keep their dwelling unit free from insects and pests and promptly notify their landlord of an infestation. In 55248.13, landlords are required to make all repairs and do whatever is necessary to put and keep the premises in a fit and habitable condition. In addition, both landlord and tenant are required to comply with all applicable housing and building codes. In Virginia Maintenance Code Section 309 on pest elimination, the owners of a multi-dwelling unit are responsible for pest elimination in the public or shared areas and exterior property. However, if the infestation is caused by the failure of the occupant to prevent the infestation, the owner and occupant are responsible for pest elimination. As you can see, depending on how these provisions are interpreted, it could be the landlord or the tenant who is ultimately responsible for the costs associated with pest mitigation. This legislation would make it clear that a tenant is responsible if they delay in notifying a landlord of an infestation or are at fault for failing to prevent the infestation. This clarification creates a bright line for who is responsible for the costs associated with pest mitigation in a tenant's dwelling unit, which benefits really both the tenant and the landlord. As a result, I'm happy to have the support of both the Virginia Poverty Law Center and the Virginia Association of Realtors for this legislation. Thank you, Mr. Chairman.
Thank you, Delegate. Are there questions at this time from members of the subcommittee? Delegate Lopez, do you have anyone here to speak in favor of your bill? Welcome, of course.
Mr. Chairman, members of the subcommittee, Chip Dix on behalf of the Virginia Association of Realtors of the Northern Virginia Apartment Association. All of our organizations have taken a look at this bill, and this is exactly what we need in the law to clarify where the financial responsibilities are. And we think that Delegate Lopez's bill does that exactly as it should be, so we support the bill. I'm happy to answer any questions.
Well, I have a brief question. It's on 13, an existing law, abide by all reasonable rules and regulations imposed by the landlord pursuant to 248.17, and that seems to allow or authorize the landlord to adopt rules or regulations concerning the tenant's use and occupancy of the premises. Is it the clarification of the financial responsibility that you really want to be the bright line that Delegate Lopez referenced, and because otherwise they might be able to assign that duty to the tenant based on 248.17 or?
So, Mr. Chairman, I would say that when you look at the bill, currently lines 18 through 20, the tenant has an affirmative obligation to keep the premises clean from any pests and insects. And that agricultural code section on line 19, 3.2, 3900 includes a whole laundry list of pests, but it also includes bed bugs, which is where a lot of the problems reside, if you will. And then there's another provision in the VRLTA, and if you've got your code section open, it's 55, 248, 13, I believe, that, or 13:2, that deals with the obligation of notification of pest control applications. And what it says in the bottom part of that section is that it requires the tenant to comply with whatever the landlord's pest control instructions happen to be. And usually in the case of bed bugs, what happens is it's, all right, so we've eradicated bed bugs in the dwelling unit, but you have your clothes and bed bugs could be in there and you need to clean those, and likewise, same thing in your furniture. So what this new language does on line 56 through the bottom of the bill is to simply say that if the tenant caused the bed bug infestation or any other kind of insect infestation, or doesn't follow the requirements of the landlord when the landlord has paid to remediate, then under that circumstance, the tenant becomes financially responsible. We think that's what the law is under most court cases anyway, but certainly this clarifies it in the statute.
And that would relate to the safety, welfare of the other tenants in the dwelling, the multi-family dwelling?
It would, sir. So what happens is if one person has, bed bugs or any other kind of insects, termites, a lot of times you end up with roaches in some communities, or ants. And if you start in one unit and you don't eradicate it in that unit, and the tenant doesn't follow the instruction of the landlord to do what they're supposed to do to keep their place clean, then that spreads to other units. And so it does have an impact on the health and safety of the multifamily community.
Are they able to assign the unit from which these pests or insects are coming? In other words, how do I know it was tenant A and not tenant B in terms of assigning fault?
So, Mr. Chairman, the way that works now is in terms of bringing a notice requirement. There's a provision, I believe it's in subsection 32 of the VRLTA, 55, 248, 32, that says that the landlord has an ability to give a notice to a tenant to make repairs or to otherwise clean the dwelling unit. And if the tenant doesn't do that, then what happens is the landlord gives a notice of termination and they end up going to court. So when they go to court, the burden of proof, Mr. Chairman, as you know, as a practicing attorney, is by preponderance of the evidence. So it would be the landlord's burden of proof to prove that the tenant was at fault, and then under that circumstance, the financial responsibility would be accordingly assigned under this bill and under the other code provisions.
Okay. And it would be, you would contemplate that the financial responsibility would not exceed the actual cost of treatment or exterminate. Does not say that, but.
So, Mr. Chairman, I would say that
They get an invoice, I mean, you'd have to substantiate what the cost was to remediate the situation.
Mr. Chairman, I would say under subsection 32 and the other provisions, the landlord has to prove the actual damages, and then they would be entitled to recover attorney's fees and whatnot, under subsection 31 of existing law. So this would be in the tenant obligation section, which is on line 12. All of these are tenant obligations, and they would have to be proven by evidence in court on the same burden of proof and apply the same principles that would apply to any of the others.
Are there questions of Mr. Dix while he's at the lectern? Mr. Delegate.
Thank you, Mr. Chairman. On line 57, unreasonable delay. How would you define that? How would you determine that? And what would an unreasonable delay? Is that somewhere in the code or?
So, Delegate Hodges, it's probably whatever the judge says, truthfully, at the end of the day. But again, the burden of proof is on the landlord. There are terms like, reasonable notice and whatnot all the way through here. And they're in the provision, I think it's 13:2, that deals with the insect notices. There's a notice requirement by the landlord at least 48 hours in advance, but then it can be amended by the least 24 hours in advance. So there's a notice requirement that would apply here that under that circumstance. And then there's a number of provisions, if you look in like line 26, talks about a reasonable manner, the use of all utilities by the tenant and so on. So this is kind of developed by case law, if you would, as to what reasonable and unreasonable means in a given circumstance. So facts and circumstances of a given case would apply.
Further questions, Delegate Hodges? You're good? Anyone else has any questions? So, I mean, this may be sort of for Delegate Lopez or Mr. Dix, just general comment. You know, in Hanover and in the town of Ashland, the local government passed some ordinances that dealt with some motels, and one of the issues that constantly arose there, their long-term stay, was bed bugs in particular. And if this situation were the law, many of those people who were in those residences, were in those residences for $50, a night or less, because that's all they could afford, or following what I'm saying. And so to be financially responsible for the mitigation of the bed bugs may put a further burden on those people who are least able to pay for that activity. And so I worry that these poor folks would then later have a judgment against them, putting them further behind. And if you have a judgment related to a tenancy, it's very hard for those people to go and get a new tenancy somewhere else, because they pull that credit and they look at that rental history. So maybe Christie wants to speak to that, because I hate to do further injury to folks who are sort of in a precarious position already.
So, Mr. Chairman, if I could respond, and then I'll turn the podium over to Christie. So, first of all, under HUD requirements, any housing choice voucher, Section 8 in public housing, HUD and the landlord have to pay for the cost of bed bug eradication. So that is federal guidance, and one of the terms and conditions of using Section 8, which is one of the reasons that sometimes landlords don't want to participate in that program. The second thing I would...
These weren't Section 8.
Okay, understand, they weren't. And they wouldn't have been covered by this because they're not under this bill anyway. So, but I recognize that it does impose a burden, but it imposes a burden on the landlord with respect to other tenants who are paying the same level of rent. So if there is a tenant, the only time this applies is when the tenant is at fault for either causing the problem in the first place or not correcting the problem in accordance with the landlord's instructions. And that's the only time this would apply.
Thank you. Christie.
Thank you, Dr. Peace. Mr. Chairman, members of the subcommittee, Christy Mara with the Virginia Poverty Law Center. And I appreciate Delegate Peace's questions and concerns, and we looked at this bill very carefully, and I can tell you that the attorneys who were really analyzing this bill for the legal aid community felt that, as Mr. Dix stated, it is a clarification of existing law, and that, in fact, under current law, it becomes a question of proof, and under this law, it slightly clarifies that, in fact, the tenant has to be somehow at fault for the existence of the bugs, or other pests, not just that there's a causation, but that there was some degree of fault. Without that clarification, there's some argument that merely tracing those bed bugs back to that tenant, even if the tenant did not do anything wrong, could result in this type of liability. So we do think it's a step in the right direction.
Thank you very much. Is there anyone else who would like to speak in favor of this legislation?
Thank you, Mr. Chairman, members of the subcommittee. Brian Gordon on behalf of the Virginia Apartment and Management Association and the Apartment and Office Building Association. Our two organizations support the measure.
Thank you, Brian. Mr. Craddock.
Mr. Chairman, Tyler Craddock on behalf of the Virginia Manufacturing Modular Housing Association. We also support the proposal.
Yeah, thank you very much. Anyone here who opposes this legislation? Okay. Any questions or comments from members of the subcommittee or motions on the bill?
Lead report, Mr. Chairman.
We have a motion to recommend reporting House Bill 1869 without amendment. It's properly seconded. Any discussion? All in favor indicate by saying aye.
Aye.
All opposed? Congratulations.
Thanks.
All right. Do we have any other patrons? Is that Zoe Campbell behind?
Yeah.
Great. 1585 and 1587. You tell us what you want to do.
I guess we'll go with numerical order, Mr.
go to the code commission? Is that where this is from?
No, it didn't actually. I can tell you that a director of local housing authority brought it to me in Marion, and basically the problem is that under the current law, only counties and cities, housing authorities have the ability to be able to construct new housing. We've simply amended the statute to, or asking to amend the statute to contemplate locality so that towns can do the same.
Okay.
Bills passed, I can get bills entertained in the Senate, passed unanimously.
Yeah, are there any questions of the good delegate? It's amazing that just striking 6 little words, 2 of which are or actually 8 words, 2 of which are or, and adding has can make such a difference. But okay, is there a motion on the bills without amendments? Properly seconded. Any discussion? Recommend reporting 1585 indicate by saying aye.
Aye.
All opposed? Okay, Delegate Campbell, number 2.
Mr. Chairman, members of the committee, House Bill 1587, there may be a substitute for or an
Is there a
amendment.
substitute for Delegate Campbell's?
Line.
Okay, line will council report the amendment, please?
Certainly. Mr. Chairman, line amendment is on page 1, line 24. After et sec, you would insert comma, except to the applicant upon the applicant's request.
Delegate Campbell, we'll take action on that. Why don't you tell us what you're hoping to solve with this legislation?
Mr. Chairman, it came to my attention middle of last summer, I guess, that private housing plans were subject to FOIA through request of the building inspector. And they know, I couldn't think of a plausible public policy reason why we would allow for that. Interest of public safety. Obviously, you would not want prospective criminals to be able to gain access to your housing plans. I could not think of a good reason why we had included that in FOIA. And what this bill will do effectively is eliminate that with the exception of the line amendment, which will allow for the applicant themselves or the homeowner to be able to gain access to plans in the event that somehow their contractor lost their plans or something.
Mr. Chair,
Yeah, Delegate Bowman.
quick question, because I understand, and I'm not sure that I would feel very comfortable with somebody being able to FOIA the layout of my house and be able to figure out a great way to break in. I guess my question is on your amendment in terms of how broadly the term applicant is, because I think applicant deals with the engineering plans, and so that's the developer who would go ahead and put those in. I don't know that it covers the property owner after the fact, and so we might actually want to go ahead and broaden that if it's going to do what you're hoping to do.
I'm not saying the contemplation was applicant or homeowner. Is that what the language says in my amendment? I'm not seeing that today.
Council.
Mr. Chairman, I had written a question, sometimes with the building permits and things like that, the developer submits them. So if you want them to be available to the homeowner, then we can certainly clarify the language, because I really wasn't sure who an applicant might be. Because it could be the homeowner or the building contractor.
Delegate Bullock, would you like to make a, we haven't adopted the amendment, so would you like to?
Sure, yeah, so I guess I'll go ahead.
Council, or you do it?
Yeah, so I guess I'll make the amendment then, or move the amendment on line 24, except for the applicant or the owner of the property. I guess it's
Or property.
Or property owner, however Maria wants to do that.
Council, that sound good to you?
Sure, Mr. Chairman.
Okay, that's a motion, seconded. Any discussion on the motion? All in favor, indicate by saying aye. Aye. All opposed? So the bill is before us as amended. The policy is, do we think that these drawings and plans should be readily available to the general public or not?
And again, I think someone's right to privacy and the sanctity of their home, I mean, that's certainly contemplated by the Constitution even. And again, I can't think of a good public policy reason why the general public should have access to your housing plans.
So let me ask you this question. I had this conversation before today. When I go onto the Hanover GIS site, I can pull up the property card information that's related to the assessor's office of Commissioner of Revenue, and I can see an outline of the footprint of the property. It would not be your idea that that also should be not available, or
That's not what I'm
that doesn't
suggesting.
raise concerns to you in the same manner that the interior, the floor plan itself.
Housing plans sometimes contemplate security systems as well. So that's obviously,
Where do you cut the wire is sort of what you're getting at, I guess.
yeah.
Okay, all right, well, thank you. Yeah, Doug and Hodges.
Thank you, Mr. Chairman. On line 21, this only applies to single-family residential dwellings. Would there be any other instances or any other dwellings where this would cover, or?
Mr. Dix, do you want to speak to that at all, or, I mean, multifamily, I mean, I'm thinking of tiny houses, or, you know, mobile homes, other definitions or classifications of housing units.
So, Mr. Chairman, I would say, Chip Dix on behalf of the realtors, I think the delegates bill, the realtors support in that if I spend $10,000 on a set of plans,
Right.
and I submit them to the locality, and then they become public information, and somebody can come in and get the plans, and find out the layout of my house, my security system, all that other sort of stuff. There seems to be in the residential environment for single-family houses, sort of a good public policy to protect that information from just anybody coming in and getting it. In a business circumstance, for an apartment community, you know, there you're talking about hundreds of thousands of dollars of plans. And so, you know, maybe it's a different policy, but it's that old saying, maybe somebody else gets their own bill, right? I mean, I think Delegate Campbell's just trying to protect the single-family owner who's invested in their house plans, and from somebody either doing something bad with them or taking the plans or whatever, and not having to pay for them, just wait to go get them from the locality.
Yeah, I appreciate Delegate Hodges' question and your response. I mean, it's maybe the Campbell's nose under the tent, but the fact of the matter is, when you think of proprietary interests, you know, if someone's building a grocery store and they've got competitors, they don't want them to know that stuff either. So, I mean, we might want to look at that for another time as well, just the commercial interest, because
Mr. Chairman, under the Freedom of Information Act, trade secrets, proprietary information submitted as part of the building plans is already protected.
so if you're building a grocery store, it would not be the same as the single-family residential dwelling that is
Correct.
already protected. So this is really putting this in line with that policy.
Well, Mr. Chairman, FOIA doesn't distinguish the building type, whether it's single family. It's just if it's proprietary because it's designed differently or something, you're doing something instead of block